All right, it's 13:59. We are ready to start. Please make sure that your devices are on silent. Thank you.
Yes, Ms. Sigazinqobe.
Thank you, Chair. Ms. Ramsamy, can you put on your, thank you. Just before the adjournment, we had dealt with paragraph 59 of your statement on page 25. We were moving on to your docket summary report. So we can start at paragraph 60 on page 25, but I just want to confirm from you that on the 9th of December, when you received the dockets, whether the dockets that we have in the bundle file 10 are the dockets that you had received, and whether they were only the Valeria and Orlando, or whether you had received others as well. So if we can go to page 117 of file 10. And I think it goes all the way to page 160.
117.
Yes, 117. If you could just have a look at whether those were, I think they are because of how you describe the dockets in your docket summary report, but I just want you to confirm.
Correct.
Okay. So if we can then go to your statement at paragraph 60 on page 25, you can start there.
Paragraph 60. On the 9th of December 2024, we received the dockets. 61. I then proceeded to prepare a docket summary report. This is a report setting out my assessment of the evidence contained in the dockets and whether the evidence revealed a prima facie case of the allegations contained in the Section 27 referral affidavit. Paragraph 62. I sent the docket summary report to Advocate Johnson on the morning of the 10th of December 2024.
Before you proceed, can we just identify the document summary report? If you go to page 163 of file 10. Are you there?
Correct. It is the correct report. It starts at 163 and ends at 165.
Okay. And how we are to understand it is that you would deal with the dockets that were referenced in the Section 27 referral affidavit.
Correct.
And did you receive the Cape Town dockets as well?
Correct.
Okay. Now, what I propose we do is we go through your report and then we can go back into your statement. So if we can go to the report at 163, I will then indicate on the docket which docket we're dealing with when you go through your report. So the first one is 403. You can go through that, and then that docket should be at page 146 to 154 of the bundle, if you can just confirm that.
Correct.
Okay. So let's go to the report at 163, and you can just read first from number 1. You don't have to read the case number, but we know it's 403.
I marked the report confidential. It is titled Docket Reports. Number 1 is 403, Alleged Offences, Corruption, and Defeating the Ends of Justice. Docket content, A clip, 1 statement. A1, F. Adams. Allegations that a polygraph test was failed in July 2024 by Major General Mudondo, who had 2 cases of tax evasion and that the head of vetting, Brigadier Ncube, was tasked to ensure that no investigation ensued. This statement is vague, does not indicate where the allegations emerged from, nor what evidence is at hand to substantiate them. B-Club has an information note to the Provincial Commissioner, Lieutenant General Mtombeni.
Before you proceed, can I just ask you, what is a B clip?
A docket is made up of when it opens up, there's 3 parts to it. So the A clip is where the statements are filed. The B clip is generally correspondence between the prosecutor, the attorney, maybe LCRC, or it also has, you'd find stapled in there the receipts if exhibits are handed in or taken for testing, then you'll have a lab receipt. So that is where we note, or as prosecutors and police officers, we would see where what is transpiring or whether this has been done, what communication has been filed. The C clip is a diary. It is supposed to be communication between the commander, the investigating officer, or the person allocated to the docket, and then later on it becomes communication between the prosecutor and the investigating officer or the commander of the investigating officer. But that is A clip, B clip, and C clip.
Okay. And then, so you were going to say something when I asked you about the B clip when you were reading about the information note?
Okay. With regards to the information note, I do not summarize it here. But in essence, because the dockets had already been in Advocate Johnson's office and we had discussed it as also later on with regards to the information note, I just want to place on record that the information notes of addressed to Provincial Commissioner state the same thing that I'm saying. There's nothing in the docket. There's an A1 and unsubstantiated allegations.
The words in italics, is that you expressing your view about the contents of the docket?
If I must be honest, Commissioner Kumalo, it's me expressing my irritation.
Why were you irritated?
We have a 27, we have a 2813. We now have dockets. I have never in my life, and I've been in NPA, and prior to that I was with Legal Aid, I have seen statements. To me, it looked like someone just went there and scribbled, it just, threw things in, which is then explained in the body of my email to Advocate Johnson when I send the report.
And just to be clear, the statement you are referring to is the statement of the complainant in the docket.
Correct.
That would be the A1. And the information note is the document at page 151, if you can go to 151 of file 10.
Yes, correct. This is the information note.
And so that was in the docket when you got it on the 9th?
It was in every docket that I received, yes.
Okay.
This information note is not an IDEC document.
No, Commissioner, it's not. It is it's my understanding of this is that when these allegations were made against high-ranking officials within SAPS, the instruction was that the Provincial Commissioner is to get weekly or monthly updates. Mr. Rapesu will speak to that because he was the one that collected the dockets and he was told with regards to that.
Okay. So then we can go back to your report.
C-clip, one entry upon opening the docket. So the entry in the C-clip is what is generally termed the opening entry on a C-clip. Generally, it would be the date, time, of the opening and the A1 being obtained, the contact details of the A1, just so that if it's not on the A1. Also, if there's potential witnesses that the A1 or the person, the complainant, has, it would be noted there. And a brief summary of the A1 allegations.
Okay, the next one, which is 404, Valeria, and it's on page 163, and the docket is at page 136 to 145, if you could just confirm.
Correct?
And those information notes were identical in each docket because it dealt with all the cases
Correct.
in one information note.
Yes.
Okay. So you can then go to your report at 163.
404, alleged offenses, corruption, and defeating the ends of justice. A clip, one statement. A1, F. Adams, alleges that he has sensitive information relating to the abuse of funds from the Secret Service account that contravenes PFMA. Further, that the docket CAS 38 of, I won't repeat, or will continue with that, in which General Lushaba was the complainant, in which Lieutenant General Kumalo, the divisional head of crime intelligence, facilitated the act of defeating. Further, allegations of nepotism, placing persons and family members in strategic key positions that affect service delivery. I make the same statement in italics. This statement is vague, does not indicate where the allegations emerge from, nor what evidence is at hand to substantiate them. B clip, it had the information note to the provincial commissioner, and the C clip again, one entry.
And then the third one, which is 405, that docket is at page 117 to 125. If you can just confirm.
Confirm.
Okay, and then you can deal with your report at 164.
Thank you. Alleged offenses, corruption. A clip, A1, alleges major abuse of power of the Secret Service account by Lieutenant General Kumalo, Divisional Com of CI, together with Major General Lushaba, the CFO of CI. Funds being channeled into the KZN Political Task Team, which is a front for the former minister, Mr. Trele, purchases of vehicles through this fund allegedly bought for the task team but used for the former minister's activities. I state in italics again, this statement is vague, does not indicate where the allegations emerged from, nor what evidence is at hand to substantiate same. B clip has an information note to provincial commissioner, and the C clip, one entry upon opening of docket.
Now then, you deal at number 4 with the Cape Town dockets, and you say, respectively, are the first dockets opened and have the same information as above. Where did you get that information from? From the bundle? Okay, and then Valeria 38 has been perused and will be relevant for evidence purposes. You don't summarize the A1 or deal with that. Do you see that?
The 38 was not one of the dockets that was referred by Adams. The 38 was what we would term an exhibit, in the sense that the claim was that that docket was not properly investigated.
Okay, which docket wasn't properly investigated? That one itself?
That 38. And that
Okay.
one was opened already in 2024.
22,
22.
yes.
Yes, my mother's not going to be happy with my dyslexia after this.
Yeah, okay. Now, you say the investigation into this matter is poor and disturbing the offense of theft.
Yes, as I had done with all the other dockets, I had thoroughly perused A clip, B clip, and C clip. I found discrepancies, but I'm not an investigating officer. My discrepancies were based as a prosecutor on the. I also realized that very little effort had gone into that docket. And had it come to me for a decision, I probably would have put a very nasty diary entry to the commander as to why it was done so, for lack of a better word, sloppy.
I may have missed it. I see it's on 161, but did we place it on record, the date of this summary?
We are getting back to it as to when it was sent, and because there's a WhatsApp before that precedes the sending of the document. Thank you. So that, and then if we can just finish off with the report, you then have 6 instructions to investigators. So this is going to, is it primarily addressed to the investigators, or is it primarily addressed to Advocate Johnson and the investigators are copied in? How do you?
Advocate Johnson had not asked for this report. No one had asked me for this report. I, upon receiving the dockets, felt compelled to do this report because of my gut instinct and whatever happened on the 6th. And then when I received the dockets itself, it needed to be reported in a manner that we as prosecutors would report dockets. When you give an evidence report, it's generally to a senior to make a decision because you're not finding what you're supposed to, or they think you're supposed to be finding, or what the SAPS thinks you're supposed to be finding, or the complainant thinks you're supposed to be finding. So, but my instructions to the investigators were based on my unease and the lack of substantiation in the docket itself.
Okay, can you just take us through your instructions to the investigators?
Instructions to investigators. F. Adams is to be consulted. Full and detailed draft affidavits to be obtained before prosecution plan can be discussed. One of the 2 prosecutors must be present when this consultation takes place. You will also note that I'm trying to now involve the DD that is allocated on paper, because I'm working on my own under the I'm going to do the supervision of Advocate Johnson. So by saying that, I'm saying one of us, either the DD or myself, need to be present when this consultation takes place.
Okay, continue.
All information, documentation, and witness names, etc., to be contained in the affidavit draft from F. Adams.
So you want the evidence?
Correct. He's saying that he has proof. He's saying that someone slotted things under his door. He's opening dockets, but he only makes vague allegations and then pops up a name here and there, and then you don't know what's happening exactly. So I wanted a full and detailed draft report or affidavit from him. And he must advise us, okay, this is a witness that I know will come forward, or this is a possible witness, and this is the evidence that I have.
Can I just ask you before you continue, why didn't you at this stage say to Advocate Johnson that section 2813 that you had asked me to apply for, to do the application for, on the 5th. I've now looked at the docket. I was uneasy before then, I'm even more so now, because in fact, the evidence that he says is contained in these dockets, it's not there. I don't see anything. So I don't think we should continue with the 2813.
That was one of the reasons I did the report. And the WhatsApps will show that I request that I send it to her before I send it to the rest of the team. My intention was to discuss it with her and to discuss my concerns on that day. However, the preceding messages that will be shown to the commission will then illustrate why that conversation never took place. It did, however, take place later on.
Which is that? Which does that?
Sorry?
You say it did take place later?
The conversation between myself and Advocate Johnson did take place in January about my concerns.
Okay. And then just before I think you should finalize or finish off with the instructions, and then we'll go back to what you say in this report and then what was in the 2813.
Prosecutors to be informed before any interview consultation to take place with any person relating to this matter. May I explain why I put this in? There was so much of speed and so much of need to get going where the prosecutor is not even ready to say, let's set down a plan of action. How are we going to ring fence? What? And Mr. Perumal was on this whole mission of, we need to do this, we need to do that, we need to contact this person, we need 28s for this, we need 28s for that, we need the files for the vetting. But I'm saying there's no substance. I don't have anything to even draft a prosecution plan. So my instruction is very clear. Nothing is to be done without my knowledge.
Would a prosecution plan precede, ordinarily, would a prosecution plan precede the kind of activity that you say Mr. Perumal was involved with, demanding or
Correct.
requiring this and that, statements being taken, that would be led by the prosecution plan?
Correct.
Okay, and number 4?
Number 4 is no section 28 is to be issued or served without the prosecutor perusing same and then submitting to the head of office for signature.
What do you mean by section 28?
Section 28, 6 or 7, for information or for persons to be consulted with or
Summoned.
interviewed or summons to be interviewed, or for any documentation books or anything listed in section 28, 6 and 7 to be done.
And why did you put that in?
Because of the way Mr. Perumal was insisting this. It was brief conversations that he would phone me and say, hey, we need to do this, or hey, we need to start moving with this matter. I was also going on leave. So, and I'm going to repeat it, and I know it's going to sound like I'm repeating it ad nauseum, but my gut was not feeling comfortable compared to the 27 I had done in 2023 versus this.
And at that stage, there's no evidence, so...
There's nothing, there's no evidence. What do you 28 if there's no evidence? What evidence are you? Are you going on a fishing expedition?
Okay, and then you say, please note that there are 5 CAS numbers allocated. Once draft is obtained, the team can discuss the way forward. This is the draft affidavit. Now, can I just understand why you were asking for a draft affidavit? Because you have the section 27. What is the status of the section 27 as in the investigation? In the 2813 investigation, what do you call the section 27 referral affidavit?
My understanding is that the 27 is supposed to be your A1.
It's supposed to be your A1.
A1.
Okay.
It's a complaint received. But that's my understanding. It's not implemented within IDAC. My understanding is if you are filing an affidavit with allegations, that is your A1. That is your complainant statement.
Can it be supplemented?
Yes, it should be supplemented if needs be. But it cannot be a standalone affidavit and from there, investigations flow in a different direction. Or not different direction, but investigations flow where we're taking now new A1s. But I was told that this was told to me in 2023. I was shut down with this. When I was dealing with that specific 27 in 2023, I held the same view, that the referral affidavit needs to be the A1 in the dockets. I was told that's incorrect and it's not going to happen that way.
So once the investigation has been authorized under 2813, was the process then that you have to then obtain a new affidavit?
No, with the previous, the 2023, I'm just going to refer to it as the 2023 referral. That complainant had come with a letter and a statement, an uncommissioned statement. When the matter progressed before myself and the other prosecutor got involved, the legal representative of that referrer submitted a very extensive formal affidavit, and that is in the docket. So we received two different, how do I explain it? So it would have been like this. We had the first where she initially, it was just a statement that she signed, and then we had the affidavit referral in 2023.
Okay, but that I suppose is different because in this instance with Mr. Adams, you have an affidavit. The section requires that it be either affidavit or it be a declaration. So in this instance, you do have the affidavit from him, but in your docket report, you're saying we must get a draft affidavit from him.
But a draft supplementary.
Oh, okay, so what you're intending is that it must be a okay.
Because also, you must also remember now, I'm in possession of original dockets, where A1's already existing. So you can never have an A1 and then take another A1 and then take a supplementary. It's an A1 and a supplementary, or an A2 and a supplementary.
Okay, and the purpose of this affidavit that you were saying now needs to, because you say if Adams to be consulted, full and detailed draft affidavit to be obtained, you put draft in bold, and what is the purpose of that? So you're not wanting a complete document from him. You as the prosecutorial team with the investigators want to sit with him and take a statement from him. And that is now part of the preparatory investigation,
Correct.
which is the 2813.
Correct.
Is that how the process works and is supposed to work?
Which process?
The process,
No, it's not supposed to be like that, but it's generally in IDAC space at the moment that people or prosecutors get draft affidavits. When most prosecutors prefer the draft only if the investigating officer is suggesting that this person is a 204. Then it would be a draft. But we generally, because we're prosecution-led, if the investigator says he needs to consult with you and he goes to you, I will constantly be updated about what is in the draft. They'll either send me WhatsApp pictures, they'll email me the draft, I'll read, I'll say, okay, but this witness is indicating that Mr. X has in his possession emails. Has it been canvassed? Or it would be, the deponent is saying, in 2024, I was in Limpopo and, whereas we have proof that he was in fact in Dubai. And I would then ask, has this been canvassed? Why is he saying this?
so You are, when this affidavit is being prepared for Mr. Adams, you're trying to gather evidence?
Correct.
To see whether there is a case, a prima facie case, but you also in that process preparing an affidavit for him as the prosecutors?
It's supposed to be that way, yes,
Okay.
because of the prosecution-led guidelines.
And assume that if you meet with him and he gives you all the documents and you're now convinced that, well, there is a case here, you then assist him in preparing that statement for him as the prosecutors?
I wouldn't assist, I would be present.
Okay.
The reason I'd be present is that I would be able to assist the investigating officers and the witness with regards to the structuring of the affidavit.
Which is what happens later on
Later
in
on.
January with
The prosecutor
supplementaries.
is not allowed to become a witness in their own matter.
Yes, that is what I was trying to understand. So when you give the instruction to the investigators, you're removing yourself as being a potentially a witness, but you're still consulting with the witness when that statement is being prepared or being taken.
Yeah.
It's just that it's the investigator that's doing the drafting and that. Okay.
Can I put it to you in a different way, in an easier way? Because of Section 28, prosecutors are allowed to consult with witnesses, right? My previous DD, who has retired, deputy director, he always said to me, because he comes from DSO, never consult with the witness where you don't have a statement, at least a draft, because you're walking in blind and you are going to be a witness. So if you're going to consult with the witness, ensure that you have a draft in front of you. You know what you're going to question and how you're going to assist the investigators. So that is what I was trying to say.
Okay. So as part of that process, you say that the Adams is consulted, and then one of the two prosecutors to be present when that consultation takes place. So you want the draft statement before you plan your before you prepare your prosecutorial plan.
If there's ever going to be a plan, because my thinking was when we go for these supplementaries, because now we've got dockets, and we instructed to investigate these dockets. When we go for the supplementaries, obviously he's now saying, and he's publicly said it, I've got documents, they were slotted under my door. Obviously in those documents, it might actually substantiate, and to an extent some of them did, I'm not going to lie. Some of the documents that I saw on the 19th of December did substantiate.
Substantiate what was contained in the A1s of the
A1s,
dockets,
yes.
not the Section 27 affidavit that we've seen? Or
Some
what?
of, no, not the one that you've seen, no.
Okay.
Because, am I allowed to speak about the forklift?
The forklift.
Yes, no, yeah.
One of the issues that I picked up here of the one that was flighted is there's no mention of a forklift at all. But Mr. Rapeso will confirm that we received, we just had to trace it, Langlaagte docket for a forklift, and it was in the 27 referral. And the supplementaries that we took was one of them for the forklift. And the first 3 witnesses that were identified were from the forklift documents.
Okay, your point being that if there wasn't mention of the forklift, why were you going down that rabbit hole of investigating the
And there is
forklift?
it was multiple consultations.
Can I just ask relating to this? What is there a guideline or what informs what goes into this draft affidavit that you're getting? And it's related to what you've just spoken to now, which is you have a Section 27 affidavit.
Correct.
And then you get the one that was flighted here, I want to use it as an example. and then you get the Mr. Rapesu supplementary affidavit that speaks about the PKTT, when the Section 27 that supposedly is the basis for the investigation says nothing about the PKTT. On the face of it, it looks like Mr. Rapesu would have sat down and suggested to the witness that you're not saying anything about the PKTT, let's talk about the PKTT, without it being found, I'm saying on the face of it, without it being founded on the Section 27. And I guess my question is, what is there that avoids suggesting things to witnesses or in a statement to avoid and to prevent, in fact, investigators imposing what they really would like to be in a statement which the witness may not have been interested in, but as seems to have happened in your cases that we are concerned about, that investigators had their own stories that they wanted to tell and that they wanted to be investigated, and they went to a witness and said, give me something that deals with this.
Generally, I would assume it's ethics and morals that would guide someone, not to do that. As we can see, it's not done that way. But generally, certain investigators and certain prosecutors don't work in isolation. I personally, since the 1st of March 2023, have never gone to a consultation without at least 2 investigating officers or another prosecutor and myself. It's the safety net. So in some groups they do, and some groups they don't, but with the team that I worked with, it was never a prosecutor or an investigator going on his own. But I will qualify that with the fact that you must also know that if you have 2 investigators that have the same agenda going to that witness, which is one of the complaints that I do make to Advocate Johnson, and it is in an email, where prosecutors and other investigators were being excluded, and things were being done in a certain way, and statements were taken in such a manner that it doesn't even give you an offense.
I guess what I'm asking is, and it's part of a debate that was had with Ms. Johnson, about what Section 2813 permits to be done, because you look at a referral, it doesn't speak to anything that you now find in an affidavit. And I think her answer about those kind of concerns, and I paraphrase how it would have been raised with her, her answer would have been along the lines that, well, when we investigate and the stuff comes up, it may not have been in the Section 27, which is silent about a particular topic. But when we now, as we do investigations under 2813, then we end up, finding this stuff, and that becomes justification for why, you have matter that looks like you went outside the parameters of your affidavit.
If I may give a practical example of, remember I did the 27 in July. So between 1st of March and April, I was given what we call alphabet soup. So we've attached acronyms because the companies or whatever, just to shorten it, that we were investigating. And I think it was towards the end of March, I had discovered that there's a link from a project that is already authorized to another docket that is within the DPCI space. It is also investigated by the DPCI that has been seconded to IDAC. But the link and the suspects are glaring. And I approached the project manager as to what do we do now, because some of the accused or identified suspects are on the 28 that's already authorized. Some are not, and the scope in which of the parameter, the legislation, that some of the legislation that's applicable to that offense is not covered in the initial 28. She said to me that we would have to do a new 28. So I said, no, but why? Why would we need to, why can't we do an addendum? Because an addendum is contractually binding, and it would make sense because we discovered it during the course of. And so there was a meeting that was set up with Advocate Johnson, and we asked her, should we do a new 28? So then I asked, but can't I do an addendum? And she said it was fine. The addendum was drafted, it was attached and filed to the original 28. And that is the process we followed with 3 other of my matters.
So that addendum would be a foundation and an explanation how you end up with these new other people that were not in the original. Thank you.
But in this instance, if the section 27 affidavit that you saw didn't have the allegations contained that you see in some of the A1s in the dockets, what do you do then if the decision is then made that, well, even though it's not in the section 27 affidavit, because it's in the dockets that have been referred, we should still investigate it? What would the process then be?
I would have still asked to do an addendum, but because in my 2813, and I'm standing by it, the original 27 had PKTT and slush fund and polygraph. That 2813 stood. However, my concerns were about what substantiated it. We know you've got resources. I've got interlocutories, I've got high court applications, I've got trial matters to be attended to, and I'm dealing with something that doesn't have substantiation.
And in your 2813, you don't mention the PKTT.
I was told specifically not to mention PKTT.
Was that in the, okay, so let's just step back. So you do the 2813 on the 6th. At that stage already, you didn't mention PKTT. Was that a specific instruction, or was it to keep the 2813 vague?
It was to keep the I was, in the 2813, I was not allowed to mention detail. I was told, keep it vague.
Okay, so even though, okay, that makes more sense. I just wanted to confirm that it wasn't, as you said earlier, a specific instruction not to mention the PKTT. It was not the detail of the allegations in the 27. It's like how you would just say this is what there was.
If I may explain why I understood what keep it vague meant.
Can you do it with reference to the actual 2813? Maybe we should do that on page 107. Because you don't mention any names or specific. So at 1.2, for example, you say the office received a complaint in terms of 27 in November. 1.3, allegations leveled against senior members of SAPS, allegations regarding the appointments of various high-profile officials, unlawful actions regarding the vetting and polygraph testing perpetuated by officials of crime intelligence. But in you saying the section 27 that you saw, names were mentioned.
Correct.
But not all the names that you were given by Advocate Johnson to be suspects.
if I can just explain
Yes.
the practical reason why maybe even Advocate Johnson said keep it vague and she knew I would understand. When we were dealing with the 27 in 2023, the names of the individuals in that investigation were so high-ranking and so high-ranking, let's keep it at that, that we kept our documents vague. Even our reports and all of that, until the investigation was completed, we would hand deliver progress reports. Information leaks.
Okay, so I can understand that because when we looked at the, which Commissioner Baloy mentioned, the consideration of mandate document, for example, doesn't really give you any detail. It's very scant. So I can understand that you would want to keep that vague, right? The 2813. But here we're talking about, so there's a mention about the PKTT. Where would one then find in your vague 2813, where do we slot PKTT in between 1.3 to 1.7?
Fraud and corruption pertaining to awarding of tenders and/or contracts within SAPs and/or circumventing of procurement processes. Because remember, it's the purchase of the properties, it's the forklift, and it's the use of the SSA fund for laundry and those things.
Okay. And the 20, this wasn't your, I mean, you've done a 2813 before in respect of the previous 27 referral, but have you only done two 2813s or you before
No,
this?
I've
or?
done multiple 2813s.
Okay.
Most of them are as vague as this.
Okay, and that's intentional, or is it always on a case-by-case basis that she gives that the instruction is given to keep it vague?
This time she said keep it vague, and I'm assuming that she understood, or she knew that I would understand because of the other matter. But our 2813s are not, we don't, we work, so we're different units, right? We've got the ESCOM, the Transnet, I work in security cluster unit. It's the Zondo recommendations for the security cluster.
Yes.
It is high-ranking crime intelligence, high-ranking SAPs, high-ranking political individuals that were alleged to have fleeted money from SAPs and SSA. So we generally keep it vague like this.
Okay. Then can we, are you covered? Okay.
Thank you.
We can go then to the email. I think it's first the WhatsApp message that you send to Advocate Johnson on page 161 of, we'll first deal with the WhatsApp, which is on 116 of file 10.
Are we going to flag the whole thing?
We are just going to deal with the good morning, Advocate Johnson. I have prepared the summary and preliminary instructions for the team. May I email them to you for your guidance before sending to the team? That's at 10:50 on the 10th.
Yeah.
And she says, yes, please.
Correct.
Which you then do if we go to, still in that same file, we go to page 161, the bottom of 161 at 10:57.
Good day, Advocate. IDAC docket summary. Good day, Advocate Johnson, for your perusal and guidance.
Okay, and she does, Advocate Johnson then later responds to that, but can we just deal with, at that stage, I think there's an acknowledgement if we go to 167 of the document, file 10. At the middle of the page, page 166, my apologies.
From Advocate Johnson, Tuesday, 10 December 2024, 11:05, to Drishanta Ramsamy Dylan Perumal. RE, IDAC docket summary. Drew, noted, thank you. Please run this by Chief. He had interviewed the complainant. It would help if he was able to peruse the document and then indicate if he thinks the complainant will have access to the details we require.
And that is in response to what is set out in your docket summary, because your email to Advocate Johnson just says for your perusal and guidance.
Correct.
So she's responding to what is contained in the docket summary.
Correct.
To say you must run this by the chief. So what is it that you're running by him? The requirement to get or the instruction to get the draft affidavit and the documentation, I'm assuming?
They have seen the documents that is in Fadil or Mr. Adams' possession. And a lot of my concerns will be calmed.
Okay, then I think we have back to the WhatsApps.
Correct.
From Advocate Johnson at page 116, file 10. So we know that she acknowledged your summary report, and then that was in the email at 11:05. You don't really have any discussions with her during that day. She sends you an WhatsApp at 16:03, which starts with the one just below, yes, please. You can read that and then take us from there.
Drew, speak to Chief. I need you guys to urgently subpoena Lushaba's bank accounts before they move money. From the date he was acting as DivCom to date.
Okay, let's just pause there. So at this stage, we know that you've sent the summary, and in that summary, docket summary report, you're saying that no Section 28s are to be issued without your perusal. Do you know whether Advocate Johnson and Mr. Perumal had any conversations during that day before she sends this WhatsApp to you?
It's evident from Drew speak to Chief, because when I called the Chief, he indicated that Advocate Johnson received information that there was 50 million rand worth, or 50 million rand of SSA money, Secret Service account money, that was being moved out of Lushaba's account. I apologize for not using titles again.
Okay. But that is when you then call him after she sends this message. She's just telling you to speak to Chief. And at this stage, Chief hasn't yet, which is Mr. Perumal, he hasn't responded to your email where you've dealt with the docket summary, because you sent it to both of them. So you then, if we can go into your statement before we continue with what happens the rest of that day. Paragraph 62 on page 26.
I sent the docket summary to Advocate Johnson on the morning of the 10th of December 2024. To summarize, I reported that there is no substantiation in the dockets for the allegations contained in the Section 27 referral affidavit. Had the correct process been followed, I would have considered the dockets at the time when I prepared the Section 2813 application for authorization. In fact, it would have been preferable to have had the dockets, since they were existing case dockets, at the time when the consideration for the mandate memo was prepared, which I was not involved in. 63. In the 6 December 2024 meeting, Mr. Perumal and Advocate Johnson indicated that the dockets are what was referred to IDAC in terms of Section 27 referral and could only be collected after the authorization. This did not make sense, and was yet another red flag that caused my unease.
Let me just understand what's being said there is that you, Mr. Adams is referring in his Section 27 referral affidavit to dockets. And what Mr. Perumal is saying is that you can't have the dockets before the 2813 is authorized, then you have authority to go and get the dockets.
What they are saying in essence is that Fadil didn't only make a referral to us. Mr. Adams, I apologize, did not only make a referral, but he referred those existing dockets to IDAC. I did not understand it that way.
Okay, so it wasn't just the Section 27, it was to investigate the dockets as well.
But
That's what he said.
It didn't read like that.
Okay. So then if we go to 64.
Since the Section 27 referral affidavit referred to the dockets, I thought that we would find in the what we would find in the dockets would be prima facie evidence of the allegations contained in the affidavit. It did not. In fact, it had no new details. Again, I need to digress before I continue with the chronology. The Commission will note from my docket summary report that the B-clip to all the 3 dockets contained an information note from Major General Kumalo to Lieutenant General Mtombeni, the Gauteng Provincial Commissioner, wherein an assessment similar to mine on the merits of the dockets were made. Advocate Johnson would have had the benefit of that information note and my docket summary report as early as 10 December 2024.
Okay, then we get to the premature summonses.
Before you do that, Advocate Johnson gave the impression in so many words that she doesn't get involved in the minutiae of reading documents, depends on, it works on briefings by investigators, I think largely, but by yourselves, that team. And so some of the things that are questionable that she was taken through to explain where did this come from, her answers would be, that's what my investigators told me. And yet here you say that she would have had the benefit of the information note as early as 10 December. Can you just explain how it worked?
I explained earlier in my affidavit, and I'll elaborate now. Advocate Johnson said she was going to be the supervisor of this matter. She was the dictator of this matter. There was not a single move for the period that I was involved, right until 2025, September. There was not a single action that was done in the Medicare or the crime intelligence that Advocate Johnson didn't know about. And it must also be noted that between Advocate Johnson and Mr. Perumal, they would talk to each other and update each other about everything. And that's why I earlier said you could have a conversation with Advocate Johnson and make sense now. And 5 minutes after speaking to Perumal, she's completely changed her mind, and we are now on the beat of what Mr. Perumal wants. So was it Commissioner or Kumalo or Chair that said it's a lie?
I'm just glad it's not me. I'm not in that list.
But
at the risk of being very badly victimized by when I get back to the office, it's a lie. It is a straight lie. There is, I will demonstrate now, Chair. You a little bit ahead of us.
But I did say, of course, that we are yet to make a final conclusion on the issue. But you, as a witness, you are entitled to say it's a lie if you consider it to be a lie.
Am I allowed to say it's a big fat lie?
No.
No. Okay, I retract. It's a lie. I'm going to illustrate now, Chair. You are, but and Commissioner, you are, but ahead of us, we are about to show how Advocate Johnson ran the project and gave instructions.
Thank you.
Okay, so we at the premature summonses, that's 66 on page 27. We already looked at the WhatsApp, but you can read the paragraph.
I need to take a deep breath before I read this and we show the WhatsApps, can I?
Yeah, I know, but take your time. It's fine. Are you fine?
I'm fine.
Yes.
Okay.
I know this topic is not an easy one, so take your time.
Thank you, Advocate. On the morning of the 10th of December 2024, 3 business days after the preparatory investigation was authorized, I sent Advocate Johnson a WhatsApp message informing her that I had prepared a summary and a preliminary instruction for the team. I was not instructed to prepare this report. Be that as it may, I asked if I could email it to her for her guidance before sending it to the team. She said that I should, which I did. She did not get back to me on the docket summary until the email aspect, which we'll deal with. Instead, later that afternoon, Advocate Johnson told me to speak to Mr. Perumal because she needed us to do urgent subpoenas on Major General Lushaba's bank accounts before they move money. She said it should be from the time he was acting as divisional commissioner to date. This instruction confused me. I had just sent the docket summary report to her, wherein I stated that there is basically no evidence to support the allegations in the Section 27 referral affidavit. And importantly, I had given strict instructions that no Section 28 summonses should be issued without me perusing them and submitting to Advocate Johnson for signature. I was not sure if you read the report at the time when she had given this instruction.
Well, I think let's just go back. You don't know whether she read, but she certainly responded to your email where you attached the report and said, speak to Chief, because he spoke to the complainant and he'll be able to tell us whether the complainant has the documentation. Your covering email to her didn't give any detail of the docket summary report, so she could have only known that you had an instruction that you must get information and documentation if she had read the report.
I think my statement there is more with regards to the instructions.
The instruction, okay.
Because
Not
she's automatically overriding my concerns now about 28s being issued.
Or you being generous to her that was in fact the case.
Correct.
That she hadn't read the instructions. But she would have had to, because the information about obtaining the documents was in the instruction.
Correct.
And she's directly telling you in that email that you must speak to the chief because the witness could have that substantiation.
Correct.
Okay. Continue.
In any of the documents, and I know you've told us about the Section 27 that you saw, and you've done that table for us. You've looked at the docket. In any of the documents up to this point, had you come upon any allegation that leads to the 50 million rand, let's get his bank account details? Was there anything?
No, Commissioner, nothing. Which is why I stated I was uneasy with this instruction. We had authorized, it wasn't even authorized for a full day. We received dockets, I only did the summary on the 10th. And on the 10th, but also my bigger concern was, how did this information come to Advocate Johnson? But I will.
Thank you.
Continue. 67.
67.2, she was instructed.
No. 67.1. This instruction confused me.
Yes, this instruction confused me. I had just sent a docket summary report to her, wherein I state that there's basically no
Oh,
evidence.
my apologies, I've been told you did read that, sorry.
Okay.
I'm behind.
Thank you.
67.2.
67.2. She was instructing me to issue Section 28 summonses notwithstanding my instructions to the investigators not to do so without my perusal. In effect, she overturned my instructions, and this illustrates how project diversion was dictated by her and Mr. Perumal. May I continue? 67.3. I could not understand the urgency for two reasons. First, the 2813 was authorized on the Friday, the 6th of December. The dockets obtained on the 9th of December, and my report submitted that day. I could not understand on what basis we could issue summons when we had no prima facie evidence of a crime. Secondly, the urgent summons from bank records would not stop the dissipation of funds in the bank account. What did it matter that the money was being moved? It would have been different if we had
Well, you skipped a
evidence-
line there. The
Oh,
bank
sorry.
records would merely.
The bank records would merely show the movement of the funds. It would have been different if we had evidence that there was an attempt to dissipate the funds and sought an urgent order to freeze the account. If there was a prima facie case, obtaining bank statements on an urgent basis would serve no purpose.
Continue.
I told Advocate Johnson that I would call Mr. Perumal. Before I called Mr. Perumal, I forwarded Advocate Johnson's message to a Signal group chat with Perumal, Padiachi, and Rapesu in the group. Thereafter, I called Mr. Perumal as instructed. He told me that Mr. Rapesu must move fast with the 28 summonses for Major General Lushaba's bank account. He said that Advocate Johnson had received information that funds in the amount of 50 million from the Secret Service account was being moved. As stated above, the movement of funds being the reason for urgent summons for bank statements simply did not make sense to me. But it was clear to me that the decision had been made that the summonses would be issued if both the chief investigator and the head of IDAC have decided that it should be. After this call, I sent Advocate Johnson a message informing her that the Section 28 summonses would be ready as soon as possible for her signature and serviced by Mr. Rapesu. I asked her if he should process it under the Valeria dockets or the Cape Town dockets.
Why did you ask that? Just explain that to us. I just wanted to understand, because you have your own investigation under 2813, why must it be issued under dockets, under other dockets? How does it work?
If I may just refer, I can't remember if the CIN number had been authorized by them
I
yet.
did, yes, that's what I wanted you. There was no CIN number.
If I remember correctly, they hadn't been, it was only later on that a CIN number was allocated to the matter.
And
So
what's
we
the
would not-
significance of the CIN number?
A CIN number is our internal inquiry reference number. We generally don't even use the CAS numbers where they already authorized. But because I didn't have a CIN number, and we were in possession of dockets, but it didn't make sense which docket to use, I had supposed to be issued on the day that the 2813 is signed.
Can you just raise your voice?
The CIN number is supposed to be issued on the day that the 2813 is assigned or signed off. But if you look at the composition of the team on the 2813 signed on the 6th of December, there isn't a project manager. The project manager is only allocated after everything is done. And that is why I say the whole process of this 2830, using Chair's favorite word, is diermekaar.
Steermaker, okay. So if you had if there was a project manager, the project manager would have been the one tasked with getting the CIN number and all of that, or what is the
Correct. I wouldn't, when a project manager is allocated to the projects, as is with most projects, I wouldn't even have direct email with Advocate Johnson. It would go me to the DD or me to the project manager, one of the two, depending on how good you are at formatting your documents. Then from the deputy director to the project manager would then take the documents to Advocate Johnson's PA. And then once it is signed, Advocate Johnson's PA would let the project manager know. He would collect it, he would scan it, and it would be disseminated amongst the team.
Okay, so let's then go to page 171, which is the WhatsApp exchange between yourself and Advocate Johnson. After you say, I will call him now, which is you're going to call Mr. Perumal, which you do. She says, thank you. And then you send a WhatsApp to her after you spoke to him.
Correct.
On page 171.
171. Advocate Johnson, it will be ready for you, your signature, as early as possible tomorrow. The service by Mancha will, tomorrow, and service by Mansa tomorrow. Should we proceed with the Valeria CAS 405 or the Cape Town case? They both have the same A1 and allegations for enrollment purposes. The Valeria would be easier. If I may explain that. If at a given point there was prima facie evidence, to use the Cape Town CAS, we would have to enroll in Cape Town. Valeria is within our jurisdiction, which is why I state same. Her reply, due to the Section 28 must use the next number in the register being the CIN register. I was thinking that we call this matter diversion. Then we follow the register, say diversion, and then no one knows what it is, and we are using our systems and process.
Okay, so that is where we get the name Project Diversion from. That's
Correct.
The first time it's mentioned.
Correct.
And did she, other than this explanation, was there ever an explanation, detailed explanation given for the choice of name for diversion? How did you understand it?
Projects that ran out of Advocate Johnson's office, that were not within the projects that ran out of Advocate Johnson's office, that were not within the ordinary SOPs, the ones that Advocate Johnson supervised herself. She gave titles to Matter X, Project Golden. There's even a project, Section 41.6, which is she's investigating internal people within IDAC.
What is the 41.6 reference to? Just, I know what it is now, but if you can just say for the benefit of the commissioners.
Section 41.6 of the NPA Act prevents a member or an employee or a service provider or a contractor to NPA from divulging information without the authorization of the National Director of Public Prosecution. It is a certificate that is given to a person where we are, for example, I'm now speaking about WhatsApps, emails that are internal. I had to have a certificate from the NDPP to allow me to speak today. With regards to that project, Advocate Johnson is internally investigating a specific person who will explain. The 2813 days, even, I think if the commissioners and chair had to see it, they'd probably, I don't know, maybe throw a chair. There's no prosecutor allocated to the matter. It is an investigating officer that reports to Perumal directly and a service provider. So if there's no prosecutor on the matter, who even drafted it?
And this is project 41-6, so, okay.
The reason I'm bringing this up is to illustrate how Section 28 has been abused. And I'm not just talking about 28, 6, and 7. I'm talking about just authorizing investigations. Has been abused for the past.
And that person will be the subject of that investigation, that 41-6. Is it just one person or more than one that you're aware of?
I'm aware of one person being named on as the suspect. But I'm also aware, because I had handed the documents to the DPCI officer through the protected disclosure that I was busy with prior to this happening, that that CIN number was used to obtain bank statements and cell phone records of multiple employees, including myself.
Yes, okay. That will be dealt with by other witnesses, yes. Okay, so we were then dealing with she says it's diversion, and we are using so that no one knows that we are using our system and process, and you say, I will advise the team. Thank you. This is still on page 171.
Correct.
We then go back into your statement at paragraph 69 on page 29.
The following day, 11 December 2024, Mr. Rapesu sent me a WhatsApp message to raise the same concerns I had. I forwarded this message to Advocate Johnson. Essentially, Mr. Rapesu suggested that we stall or park the summonses until we had consulted with the complainant, because his affidavits simply did not set out a case. I paraphrase.
Okay. Before we deal with that WhatsApp of Mr. Rapesu, if we can then go still on the 10th, we then get a response to your docket summary email. Mr. Perumal responds to that, and that is on page 168. I think you send him an email at 11. My mistake, I forgot to mention that at 11:16 on page 169, you send him an email after Advocate Johnson says that you must speak to Chief. You send him an email at 11:16 on that same day saying, hi Dylan, trust this finds you well. Then you can continue from there.
As per trailing, please advise, the A1 indicates that he has sensitive information.
Let's raise your voice.
Sorry. As per trailing, please advise, the A1 indicates that he has sensitive information. After your consultation with him, can you indicate what does he have in his possession that substantiates the allegations? Does he know of willing witnesses? The report in the docket is very vague, but alludes to him having sensitive information to assist with the foundation of the investigation.
Okay, just before you explain this, in the call between you and Advocate Johnson that we played earlier, the recording on the 22nd of July, you say to her, it's all in my emails as to what happened. You can look at, there were emails that were sent on the 11th or the 12th. These were the emails you were referring to?
Correct.
Okay. To say that Dylan had indicated that he had spoken to the complainant.
Correct.
Right. And that, if we go to, because you say to him, you referring in your message to when you consult, after your consultation with him, suggesting that there's still a consultation